Well, I mean, I've got Selwyn's home address, and I've sent him an invoice for 3 months. I mean, I've given him every opportunity to contact me or in multiple ways.
Yeah, I understand.
You know what I mean? I've followed
Reasonable.
I'm being, perfectly reasonable. I mean, I've got a written form, and I've also got an email from the court services manager, Carl Lewins, stating that Selwyn was the author of that document that he had me sign, giving me the order. And if you're a lawyer, you can tell me, does the referee not have to identify himself if I'm a party to the proceedings?
Generally, yes. Generally, yes. Generally, yes.
What I did is I sent the invoice of a $25 removal fee for me to remove that video off of my channel. As far as I'm aware, Selwyn had no jurisdiction to order me to do anything in regards to my own property such as that. He may have, some jurisdiction in regards to the traffic infringements and all of that matters that were before him that day, but he didn't have any right to tell me what to do. And, if he had ordered me to hop on one leg, I would have done it, but he'd been billed. There would be a bill for it, put it that way. So, yeah, I'm back in, I think it was December or January. It would have been December. I sent him an invoice for $25. January, no response whatsoever from him. I sent him a reminder notice, 30 days overdue. Please pay immediately. Then roll on February, send him the final reminder. Now 60 days overdue, and now we're 15th of March. So I've given him ample time. I've been reasonable to pay. Now, I was just curious as to whether or not I should send him a notice of default prior to filing a disputes tribunal, and it's only a $25 fee, a $25 removal fee that I'm charging Selwyn, and it's going to cost me $45 to file the disputes tribunal, but it's never been about the money for me. It's been about the principle of the matter. If someone orders you to do something, charge them for it, and don't just do shit for free. At any time, or you go anywhere for anything, there is a charge for any piece of paper, prescription, doctors, any certificate or doctor or paperwork, anything you ever get, there's always a fee or an administration cost of some sort for it. It's costing me a $45 filing fee to file this claim, for instance. Okay? And which is fine, because they're also providing a service, so of course you expect to pay. No issue. Again, not about the money. So I've got all of that evidence. I've got the emails from Carl identifying who it was that authored the documents in question. And in the document it states that I acknowledge that granted I've signed it without protest and duress, which means I can't be held liable. But I have evidence that he authored it. He pre-authored it before the hearing, which is the bit that really got me. So he'd spent time researching me, researching my channel, and he said to me, because I asked him, he said to me that it was the only video on my channel that he had watched. So just out of sheer potluck, out of the 4 parts, I believe it was, of that particular 17th of March, he just potluck picked the third one that showed the inside of the courtroom. You see, I find that hard to believe, but apparently he has that magical ability. Perhaps it was pointed out to him. Don't give a fuck. Either way, I'm being reasonable. I'm using their processes. I'm doing the 30, 60, 90 day notices. Now, what I did is to make sure that I wasn't, that I'm following procedures correctly. I called the Citizens Advice Bureau first, asked them for direction. I went online to the Ministry of Justice's website. I also went to consumer.org.nz Consumer.org will only help out members, paying members of their organisation. If you're a member of the public, you're shit out of luck, so don't even waste their time. Just go to Citizens Advice, and Citizens Advice will either make an appointment for you to have a 10-minute free legal consultation with a lawyer, and that lawyer may or may not be the type of lawyer that can specialise in what you need help with. When I went there for my 10 minutes worth one day, I got a lawyer that's not a court lawyer and had no idea how to help me whatsoever. Best advice he gave me, when he said, when you got pulled over by the cop, he says, did you speak to him? And I went, yep. And he goes, well, that's what you did wrong. Okay? And that was from him. That was the best advice he could give me. Don't talk to cops. Alright? Anyway, so, enjoy this. I'm going to supply all of the evidence, as I've said, of me filming these people and calling these people, so you can see what's been said and what's going on. The information, the lady that rang back from Waitemata Community Law, they managed to catch the entire conversation on record as well.
Hello, Mark. It's Cecelia calling you back from the law info line. How are you?
Yeah, good, thanks. And you?
Is it the time to talk right now? I'm well, thank you.
Yeah, good.
How can I help you today?
I've got a 90-day overdue invoice, and I'm wondering if I needed to give a notice of default first or something like that before filing disputes tribunal.
Okay, can you tell me a little bit more?
Oh, okay. It's a $25 removal fee that I charged a man for removing a video off of my YouTube site. It's been given a 30-day invoice, then a 30-day reminder, then a 30-day final notice, so he's had 90 days, so he's now over that, and I just need to know if I need to give like a notice of default saying that he's now, it's now in default, court proceedings going to happen, or whether or not I can just go straight ahead to, doing disputes tribunal.
Right, sorry, how much is the fee?
It's a $25 fee, and I know it's going to cost me $45 to lodge the claim.
Yeah.
But it's not really the money's not really it's the principle of the matter to me. I mean, the man involved is actually the president of the Auckland JP Association, Selwyn, and I was at court at the time in regards to a matter with the police and a speeding ticket and a failure to produce a driver's license. And before that hearing even happened, Selwyn ordered me to remove my video off of YouTube, which had nothing to do with anything whatsoever of the court, and if he's going to give me an order, he can pay for it. I did actually give the court, I gave North Shore District Court and the police my fee schedule before attending that day, so they were aware.
Alright, well, I suppose, just thinking, what's the best way forward for you?
Well, I mean, I've got Selwyn's home address, and I've sent him an invoice for 3 months. I've given him every opportunity to contact me or in multiple ways.
Yeah, I understand.
You know what I mean? I've followed I'm being perfectly reasonable. So why he's not dealing with the matter? I've also spoken to North Shore District Court in regards to my time for attending that day, and I'm trying to find out from the North Shore District Court who to send my invoice for my time. Do you see how that works?
Yeah.
Is that not fair?
Yeah, okay, yeah, I get where you're coming from, but alright, let's just try and think of the best way to get that fee.
Yeah, well, to me it's take Selwyn, the man, not the Justice of the Peace, to court and get him to pay it. Because he clearly, he forced me to sign an acknowledgement that in it states that I'm to remove this video within 2 days or I'm going to be held for contempt of court. And he made the threat of arresting me by the 21st of May, and the court hearing was on the 19th of May.
Alright, then I would suggest that you go back.
I mean, I've got a written form, and I've also got an email from the court services manager, Carl Lewins, stating that Selwyn was the author of that document that he had me sign, giving me the order.
Okay. Why don't you,
I got evidence, transcript. Got the transcript of him giving me the order as well.
alright, so just, why don't you advise the courts and also...
Well, I have. It's in the legal department of the Ministry of Justice, and nobody from there will respond to me.
Okay, so why don't you just, if they're not responding to you, then maybe why don't you just file...
File it to the disputes tribunal and not even bother with giving him a notice of default?
Well, I mean, I think you should give them a notice and file for... Because you've really tried to ring them to advise them and they're not helping, so then you're taking the next step.
I've got countless emails. I've also got, I filed a complaint to the Auckland JP Association in regards to, as far as I'm aware, and if you're a lawyer, you can tell me, does the referee not have to identify himself if I'm a party to the proceedings?
Generally, yes. Generally, yes. Generally, yes.
Right, well, I asked him 5 times during a 4-hour hearing to identify who he was, and he flat out said no on the transcript.
Oh, okay.
That's a breach. Is that not a breach of the procedure rules or something?
Yeah. But can we, I know there's many breaches, but you're wanting a 25...
Oh, yeah, well, this is just, if he's going to give me an order, he can pay for it. I'll give him an invoice and we'll just go through the procedure on that one. Alan Hart, who's the registrar of the New Zealand JP Federation, won't even speak to me anymore.
Are you wanting to raise a complaint against...
New Zealand Law Society won't help me either. I've lodged complaints through that in regards to... They won't deal with JPs because, New Zealand Law Society only deals with lawyers and members on the enrolment, and JPs aren't.
Well, they're not enrolled and...
No. So the New Zealand Law Society has no jurisdiction within Justice of the Peace. I've spoken to the Judicial Commission, Conduct Commissioner. They only have jurisdiction over judges, and even though it's supposedly a judge-alone trial, there was a JP sitting there, well actually 2 of them, which the Parliament have stipulated are exempt from the Judicial Conduct Commissioner.
Try and focus on some solutions here.
Yeah, go for it.
So I'm just thinking, so you've tried to advise the courts.
Yep.
And they're not helping out. So I think the next logical step is to, file another claim against
the JP.
Party who pay.
And what about the not identifying himself? Should I bother even wasting more time worrying about it, or just leave it?
No, I think you should just leave that.
Okay.
Okay.
So do that, and I can just send him a notice of legal, proceedings against him or something.
Yeah, and just put in like the 3 note, put in like
that we've exhausted all attempts of correspondence and.
Yeah. All right.
Yeah. Thank you so much. That's really helpful information, eh?
Okay.
I appreciate it. You have an awesome day, eh?
You too. Bye.
Thank you.
She understood where it was going. She saw the different facets of what the problems are, and I do agree. There's no point beating a dead horse. I'm not going to get anywhere complaining about the misconduct that Selwyn clearly acted out of office in that day, and him rewriting words. But I am going to use his statements against him. He is going to be held accountable. He made the statement in court, on record, that the words ask, request and order all mean the same thing. So if you get sent a request, or if you get asked something, bill them. Because according to them it's the same as an order. And that kind of takes the oomph out of a court order. So is it just a court request then? Is it a court asking something? Or is it a court order? Because if they all mean the same thing, I know 2 out of 3 of those things I can refuse, and the 3rd one I can charge for. So, we'll just let them ponder about that one for a while. What I've got here is I've got the invoice from, when was this dated? 2nd of December, 3rd of January, and 5th of February. So, there's the 3 invoices that I've sent to Selwyn. I've got the emails here where I've emailed Carl Lewins asking him for the name and the details of who the Justice of the Peaces were. because they refused 4 or 5 times during the court hearing to identify who they were. That's another breach. As a party to the proceedings, you have a right to know the name of the referees that are judging the matter or making the decisions. Of course it makes sense to know that, but he refused flat out, and that's all in the transcripts. Transcript number 2, if you want to look it up on my channel, just search for transcript number 2. And then I've got Carl's response there, Ministry of Justice response, where he's telling me the names of the people, the names. I have initially requested the first part of the hearing to be transcribed. That's the part where I was ordered to remove the video, and the order to remove your clip. If you require definitive hearing transcripts, please let me know, and I will request this as well. Justice Pieces, who presided over the hearing on Tuesday, were Mr. Hallworth and Mr. Cave. The order was made, and the document which you were asked to sign were made by the Justice of the Peace, Mr. Hallworth and Cave. Alright, so he's confirming, third party confirming who authored the documents, and he's the manager of the court services. And I also have this here, a direction, New Zealand Police, and it's just a direction to the Justice of Peace and Cave in regards to the 19th of May. Mr. Registrar, just to emphasise that the order that all phones are to be switched off and there is no recording whatsoever within the confines of this courtroom, that is an order of the court. So is it a court of record? Or is it, sorry, got it wrong. It's a court of law. It's not a court of record. So they can do whatever the fuck they like. It's a court of law. There's a different, you people don't seem to realise you're not in a court of record, you're in a court of law. They make the rules. And that's signed at the bottom here, well not signed, but named R. Cave and S. Hayworth, Justice of the Peace. And this is the acknowledgement form here. The acknowledgement that I, Mark Little, Eric King, Waitemata beneficiary, made an audio-visual recording of the North Shore District Court on the 17th of March without the knowledge or permission of the presiding judicial officers. Well, I didn't need their permission. As to whether or not their court staff informed them, that's not my issue. But I certainly gave notice to the court staff that I would be doing it. So, not my problem if they're not getting their fucking information from their court staff correctly. 2 signs forbidding photography, video filming and voice recording, instructing that mobile phones should be turned off, are located outside the courtroom. Are they? Didn't notice any, didn't really care. The presiding judicial officers ordered in the North Shore District Court at the commencement of the proceedings today that all phones would be turned off. Make any video or recording without their prior permission. I have made no request to audio. No, well, that's right, I hadn't. But I certainly did give notice of my wish to do that recording. So I don't know if that's a request. I didn't want to get billed, but I did give them notice of it. Point 5, I acknowledge the order and state that I have not and will not make any recording of the proceedings in the District Court without obtaining private permission. 6, I further acknowledge that non-compliance with the order given in court may result in me being held in contempt of court. Possible penalties for contempt of court include a period of imprisonment or fine, and that's dated 19th of May. And at the start here it says, I have been ordered to remove that the recording from the internet by 5 PM Thursday the 21st of May. Okay, now I took that video down on Wednesday the 20th of May at about 11:30 in the morning. Doesn't necessarily mean that another almost identical copy of that video didn't get re-uploaded afterwards. Doesn't mean that at all, but it certainly means that the order was complied with and that video was removed. Copy of my fee schedule, just to show that that was all, you know, given to them. 8-page fee schedule. So this is all going to be entered as evidence at the disputes tribunal. So there's all my fucking fair and reasonable attempts to make contact with this man who's acted in total dishonour so far, and that would be, yes, Mr. Hallworth, you Selwyn, if you're watching